Welcome to San Joaquin Spotlight, a public affairs program featuring conversations about life in the central San Joaquin Valley. This program is brought to you in partnership between KFSR 90.7 FM and CMAC Fresno. I'm your host, Sevag Tateosian. Today's interview is with Steven Hrdlicka. He is an attorney at law. Welcome to the program, sir.
Thank you very much.
You know, while we were setting up the stage for today's interview, I told one of my colleagues who's a volunteer on the program, I said, you know, it's Mr. Hrdlicka today. And he said, oh, I know him. He's done lectures before. So apparently you're out there in the community. Talk about these lectures that you've done.
I've been doing this for many years. I'm on the board of directors for the California Apartment Association Greater Fresno Division. They represent landlords of owners and managers of rental property. And as such, I've really focused on that and have developed, and I teach many courses throughout the year. We have perhaps 4 that are approved by the State Bar of California in addition to everything else. So we actually have attorneys that show up for these classes as well.
You know, this is an interesting area of law that you practice in. It's landlord-tenant, but your emphasis is landlord, am I correct?
That's correct. Owners and managers of rental properties.
So how did you get into this area of law?
You know, I came by it somewhat naturally in that my grandfather was a landlord. My father was a landlord. I'm a landlord. My son has been a landlord. So it's in our DNA, I suppose. And the very first law firm that I worked for, I was kind of funneled into that area as well. And I enjoy it. I have done other things throughout my career, there's no doubt about it. I also do a fair amount of collections currently, and I've worked on all sorts of real estate matters, and you know, a few years ago, a few divorces and things like that, like a lot of young attorneys, kind of a wide array of things. But over time, I think many professionals focus their practice in a particular area, and that's exactly what I did.
What is it about this area that's appealing to you? And the reason I ask the question is, you know, let's be honest, landlords are vilified in the media. They're the rich, they're the wealthy, and I say that in quotes, obviously, but you know, it's easy for people to say, oh, that attorney is just representing rich people.
Well, you know, and that's, of course, the furthest thing from the truth, and I know you know that. I feel like I'm representing the guys wearing their white hats most of the time. They, you know, oftentimes it's a mom and pop, and they bought a home, you know, moving up in life, so to speak, and decided to rent their old home, and then someone fails to pay the rent. Not only do they not get the rental income, then they have to pay my office to perhaps do an eviction, and also oftentimes the property's damaged, so they get this triple whammy, and the laws are difficult at best, and so I've always taken great pride in being able to take what I think is a difficult subject and make it easy to understand.
California, a lot of people will say, is a tenant-friendly or tenant-oriented state. I mean, you read online and people say, oh, you're in California, that's a tenant state. I mean, what do they mean by that, and are they true?
I think that's an accurate statement. There's no doubt about it. In California, the laws are geared for tenants, primarily for tenants. There are a few things, there's no doubt about it. You know, the pendulum can swing both directions. But for many years, it's overwhelmingly in favor of the tenants. And I think by and large, that's true in the collection industry as well, very consumer-oriented. And so those folks that are, you know, just trying to do their job and just trying to collect something that's due and owing them, it can be very difficult.
There's something called a 3-day notice and a 30-day notice and a 60-day notice. I don't know if there's a 90-day notice, but...
There is.
Okay. I mean, how do you determine, and this could be a loaded question, but how do you determine what notices apply to what circumstances?
Well, of course, you know, once you know the law, it's not all that difficult, but for the average person, it can be very difficult, and oftentimes what we find is that they'll buy a book or they get online, and they're on their computer and they see all these various notices, and there's a 3-day notice to pay and a 3-day notice to perform and a 3-day notice to quit. And the average landlord will take a look at that and say, that's the notice I want. I think they're selling drugs, or I think they're having too many wild parties, or whatever the case may be. I just want them gone, and they'll select the wrong notice, because a 3-day notice to quit is generally used for health and safety issues. You know, if somebody points a gun at somebody and fires it, that's a 3-day notice to quit. You can't fix that. You have to leave.
And so what happens in the circumstances where you've got this young landlord, or the landlord that maybe rented out a house that they used to live in and upgraded, and they select the wrong notice? Does that throw everything off?
It does. If the notice is wrong, not prepared properly, it's fatal. Most commonly, they've changed the 3-day notice to pay rent or quit is the most common notice. And it must list their name, the address, where the rent can be paid. There has to be a phone number for the landlord so that the tenant can call the landlord and say, you're not here, or what are your normal hours of operation. A fair amount of information has to be contained on those notices. And my staff, absolutely great staff, best in the world. They are highly trained. They know exactly what they're doing. I would say that we reject about half the notices that come through our office.
And by rejecting, you know, could it be that maybe the name is wrong? Is that a fatal mistake?
It could be as simple as that. It could be that the zip code is not included on the address. And the problem with that is then when it ultimately might get before a judge, the judge cannot be assured that that tenant actually did get the notice. So the address has to be letter perfect.
Talk a little bit about what cases you take and what cases you don't. I mean, is it something where somebody calls you and you immediately take the case, or is there a process for you to kind of vet the cases?
There's more of a process, and it's kind of a cop-out to say it's on a case-by-case basis. That doesn't say much. We ask some fairly basic questions. Oftentimes, it's a failure to pay rent. The tenant has failed to pay rent. That tends to be a little easier because there's usually a written rental agreement or lease, using the terms interchangeably. And so we know the date they're supposed to pay. We know the amount they're supposed to pay. Obviously, they knew they were supposed to pay it, but the law in the state of California requires that they get a 3-day notice to pay rent or quit. And as long as the notice has been prepared correctly, then we can proceed. But we do ask a number of questions, making sure that everything leading up to that point has been done correctly and that it's going to be done ethically as well.
Is there a cost to this whole process of even filing? I mean, obviously your time is very, very valuable. You've been through law school and all that stuff, and you just mentioned that your staff is highly trained. But other than that, the court fees, I mean, could that rack up?
Oh, definitely. It's not unheard of for someone to be in the $550 range with the filing fee, the process serving. You have to essentially pay for a writ to be issued. That's the piece of paper that the sheriff needs in order to evict somebody. And then the sheriff's fees keep going up as well. So $550, $600 just in court costs alone without any attorney's fees.
That's incredible. And so what are you finding that a lot of landlords are doing their own research and trying to do it on their own? And if so, what advice would you give them?
You know, I am. I do find that a lot, and it's very dangerous. And it starts in the very beginning. It starts with online forms for credit applications, rental applications, and leases. And oftentimes those documents are just bad. They're incorrect, particularly the leases, because there is certain information that has to be included in the state of California. And if that information is not included, it can be fatal down the road. It can be very dangerous, legally dangerous, to use those forms. And yet landlords read these forms from Florida, Chicago, wherever it may be, and think that they're doing a great job. And then when it comes to the eviction process, everybody can become an expert overnight. And so they feel that they have a handle on it. And you know, there's a certain percentage of cases where they could handle it on their own quite competently, but the devil's always in the details. And what we find, generally speaking, time is money. They spend considerably more time doing their own eviction than if they just come to us in the first place. And that lost time translates into lost money. If you do the math, they're probably ahead by using an attorney, whether it's me or someone else.
You've talked about this a little bit on the program today, but what are some, I want to call rookie mistakes, or what are some devastating, actually devastating is the better term, what are some devastating mistakes for landlords to do?
I think the number one mistake that's made that I see quite often is that they don't adequately screen their tenants. The nice young couple shows up and they feel like
dressed properly.
And anybody can say the right thing. It's like a job interview. You can say the right things for 15 minutes. And so even someone who's been evicted, maybe multiple bankruptcies, other creditors are chasing them, or maybe they're just behavioral problems. You know, they may want to put a meth lab in your rental unit, and properly screening those folks can help eliminate that. It won't take care of it entirely because certain things will slide by no matter what you do. But the landlords that don't do any screening are the ones that get burned often.
Tell us a little bit about, while you're going through law school, I'm going to take you back a little bit, but while you're going through law school, did you know that this is the area for you?
I knew it was one of the areas. I knew that I I had, and in fact, just backing up for a moment, even now I'm involved in a number of different businesses, not just the law firm. And I've always had that need, want, desire to learn new things. And as an attorney, it affords you that opportunity. Reading contracts is second nature. So a lot of the things that would prevent the average person from engaging in a different type of business haven't slowed me down. And I've been able to do that over the years. I've had some great partners, very knowledgeable in everything that they've done, and I've been able to kind of ride their coattails to a certain degree. But with regard to landlord-tenant, there is a need to take what can be a complex matter, even the 3-day notices we were discussing. There are so many things that have to be included. It takes a while to have a command of those things and be able to educate your clients on how to prepare one, how to serve it properly, which is another big issue that's commonly, a lot of mistakes are made commonly.
The legislator is always bringing up new laws. Since you've been practicing, and you've been practicing for a while, has there been any new laws that have come out, and has your job as an attorney for landlords and managers been complicated?
It has, I don't know how a new attorney would get into this area of law and understand everything overnight. It just is impossible. I've been blessed in that it was much simpler when I started back in 1985. And over the years, over those 30 years, they have made it considerably more complex, but I've been able to grow, along with it, if you will. And we've also increased the number of staff that we have. We were just talking about it this week, in that the average case that we handle, because of the complexity, has increased probably threefold over the amount of time that it used to take.
Are you in trial often? I mean, talk a little bit about what the day looks like for Mr. Hrdlicka, because you have great staff, and by the way, I know several of your staff members. They're awesome people, so congratulations.
Well, thank you.
But talk about the day for you. I mean, are you in trial? I mean, are there times where you're actually taking these cases to trial?
Oh, absolutely. In most courts throughout the state of California, just because of budgetary problems, they have consolidated the courts, and the same is true in Fresno County. In Fresno County, they've taken all the courts, and so courts that you would have found in Coalinga and Fireball and Reedley and Sanger and various far-flung places, even as close as Clovis, they've consolidated them all under essentially one roof. So they basically have now 2 courtrooms on a Tuesday morning. They'll start off with all the unlawful detainers, fancy word for an eviction, all the unlawful detainers for the week for the entire county. And so it's very, very busy. But those judges are quite talented. They get to know that area of the law very, very well, and they're very efficient with their time. And as one attorney and perhaps tenants are outside talking, they're dealing with another case inside the courtroom. So the fact of the matter is, we've handled many trials on a single day in Fresno, and then Madera and Hanford and Bakersfield and the other places that we practice.
Who are representing the tenants? I mean, do they hire their own lawyer, or are we looking at nonprofit organizations and organizations out there that, are tenant rights type of organizations?
They can hire their own attorney, although that's rare. Usually it's some sort of nonprofit organization. Central California Legal Services has some very talented folks that assist tenants in preparing the answers, and then depending on the occasion, they may actually show up in court. There are several tenant groups now that have sprung up over the last couple of years. They have very talented attorneys as well, and they'll take a look at it. I actually appreciate having an attorney on the other side because they understand the law. They know what I'm saying is accurate, and where we're going to go with the case, whatever it may be. Oftentimes they're just trying to keep it off their record, and they recognize that with an unlawful detainer on the record, with an eviction on the record, they're going to find it, the tenants are going to find it exceedingly difficult to find a quality place to live in the future.
And are there times where you ask them, hey, your client hasn't paid rent, or hey, your client has been dealing drugs in the property. Why even take it this far?
I do that all the time. I tend to be somewhat outspoken, and I ask too many questions in that regard. But I just feel like sometimes you look at a case and it just doesn't make any sense, and so I ask them straight up. Why did they choose this or that? I have found out over the years, I've determined over the years, that the primary reason most people get evicted is just poor life decisions. By way of example, just a small story. The first time I had someone tell me that the fair was in town, and I said, wait, pardon me, I didn't understand that. And they said, well, the reason I didn't pay rent was the fair was in town. And I had to quiz them a little bit more, and they said, well, I had to take the kids to the fair. So I learned that they make poor life decisions, and they decided that going to the fair and getting a stuffed bunny was more important than keeping a roof above their head. And although the average person would not look at that and think that that's wise or logical, you would be amazed. The number of evictions that we do during the time that the fair is in town actually goes up.
It's so interesting to me because, you know, your priority, at least my priority, is paying my bills first and then going to the fair. But it sounds like what you mentioned, people and their choices in life. So when you get a situation like that, how do you handle it? I mean, do you just go in and try to negotiate with the attorney and, you know, try to work it out?
We always try to negotiate. In fact, the courts encourage both sides to go out into the hallway or an adjacent room and talk about the case and see if there's some way to arrange some sort of settlement. In fact, the Fresno County Superior Court has a contract with the Better Business Bureau, and the Better Business Bureau has some very talented mediators that show up every time that they have one of these calendars with unlawful detainers, and it's their job to try to wade in and see if they can't facilitate some sort of negotiation. They don't take sides, they don't practice law, but as trained mediators, as trained neutrals, they can oftentimes answer the questions that these folks have. And also, I think it's a little disarming when you have someone that doesn't have a stake in it. You know, it's one thing for me, the enemy, if you will, to make a suggestion to them. We would never intentionally misrepresent anything, but I understand that they're going to take what I say with a grain of salt. But a trained mediator, a trained neutral, I think they put a little more weight in what they have to say.
And are there situations where landlords are simply getting burned? I mean, see, and the reason I ask this question is because in the media, you know, it sounds like, oh my goodness, the landlords have it made and the landlords are just making all this money and, you know, the poor tenant doesn't have any funding or doesn't have any money. I mean, is there times where you see cases and it's like, you know what, this landlord just got railroaded?
Well, I think the biggest misconception is that we'll go out and we'll get a money judgment and then the novice landlord would say, when do I get paid? And the experienced landlord recognizes that the answer to that question is probably never. Statistically throughout the nation right now, only about 2% of all the unlawful detainer judgments are ever collected. Those are very dismal figures. Now, here in the central San Joaquin Valley, with my office at least, we've been able to increase those numbers dramatically, and it depends on the property. We've had properties as high as 95%, which is just way off the chart, and you know the landlord's doing everything almost nearly 100% correct. But I would say, you know, even a bad property, we just ran some statistics on a couple of properties that we represent. We're at about 20%, so that's 10 times the national average. So obviously we've got this huge success rate, but it's still only 20 out of 100 cases that we're collecting.
So is it a collection issue? I mean, what happens, so someone wins the judgment, let's say the landlord wins the judgment that the tenant messed up the house, hasn't been paying and all this stuff. Now, does something get attached to the tenant?
There are a couple answers to the question. It's somewhat a complex question, in that there are two things that happen in the normal unlawful detainer. The first one is possession. The landlord's always interested in trying to get possession back of the property. The second thing that occurs is that you get a money judgment. And then, of course, you have to collect that money judgment. Unlawful detainers are what they call summary proceedings. And the best example I can give you of what that means is they move with lightning speed. In a normal lawsuit, you'd have a 30-day summons. In other words, the defendant, the person being sued, has the ability in about a month to get all their evidence together, witnesses, so forth and so on. In an unlawful detainer, it's a 5-day summons, so it happens 6 times as fast. Everything happens with that kind of speed. Because of that, the court, the system, severely limits you in what you can ask for. You can ask for back rent, the attorney's fees and court costs, but no cleaning and damages. So if they leave having destroyed the place or damaged, you know, beyond the security deposit and whatnot, that would actually be a separate lawsuit.
And would it be through your office? I mean, does your office handle those type of cases as well?
As far as I know, my office is the only one in town that does both. There are a number of very competent attorneys that do unlawful detainers in town, and there are a number of attorneys that do collections, but we match the two up, and we've been very successful at it. We actually have a collection agency in-house, and we can collect the unlawful detainer judgments. We also collect what we call move-outs. In other words, in the middle of the night, somebody just ups and moves, which is great for the landlord in that they don't have to pay for the unlawful detainer and go through that headache. But with regard to cleaning and damages, that might still be an issue for which they have to collect.
Negotiation tips. What advice would you give a landlord who is maybe in the process of negotiating with a tenant a move out or something in that nature?
Well, interestingly enough, there are a number of ways where they can avoid my services altogether. And I somewhat feel like when I was a kid, you know, the dentists around the country had all these ads to brush your teeth so you don't get cavities. And as a young kid, I thought, well, that's the stupidest thing I've ever heard of. You'd think a dentist would want more cavities trying to get to work. But the opposite is true. I think professionals, doctors, in this case, as an attorney, I only want to see those folks that actually need my help. And so to the extent that they can do something on their own, by way of example, if the tenant legitimately can move out in a day or two, fine, you know, work out the agreement. I think the pitfall is the landlords that believe too many of the stories they're told. And oftentimes the tenant just has one story after another. Their mother's died 3 times. And it can be difficult for the novice to pierce through that and figure that out. Unfortunately, I've heard so many stories, I think I'm pretty good at figuring that out.
So your advice to landlords, thick skin? Or, what, the nice landlord?
I think the number one thing in that regard would be to follow the rules. In other words, if it's important enough to put a rule in a lease or a rental agreement, they should follow it. So if the rent is due on the 1st, perhaps late by the 5th, and a late fee gets tagged on, they need to impose the late fee. And the reason for that is accountability. It's somewhat like you're a small child and you say, look, if you eat your dinner, you can have dessert. If you don't finish your dinner, you can't have dessert. And so the wise parent sticks with that instead of always making an exception. Well, it's a birthday, go ahead and have the cake. No, I told you. You eat your dinner, you get the dessert. So it's the same with landlords, I think. They need to have those rules. If they say no pets and they bring a dog in, they need to do something about it immediately. And the same very oftentimes with rent, what will happen is, well, you know, he gave me, such and such a story, and so I waived the late fee. And I think that's a terrible idea.
It's setting an example is what you're saying.
That's exactly what I'm saying. It's setting a poor example that you're going to waive the rules. Whereas if you say, no, these are the rules, we set them up in advance, everybody knew, everybody agreed, I'm just following them. I'll be fair, but I will follow the rules.
So we've been talking about landlords and, you know, the nightmare tenants in the program so far, but I'm sure you've seen landlords too. In all defense to the tenants, I'm sure you've seen some landlords that have done some things that you're like, oh, why would you do that?
Unfortunately, it does happen, and I think we're very fortunate in the greater Fresno area that the vast majority of landlords are doing a great job and they're taking care of business. And I think also that some of the landlords that are vilified, the ones that you hear about occasionally, unfortunately, they get a bad rap, and one of the reasons for that is that they tend to deal with low-income properties. There are more problems. It's just the way it is. Someone comes here from Mexico, let's say, and they're completely undocumented and whatnot. They still need a place to live, and there's someone that's willing to take a risk on them. That's a tough one. They don't have any family here. They don't have job history. They don't have any credit. You know, all the things that you would normally look at and say, oh, here's a good tenant. They don't have it. So they're taking a risk as far as that goes. And they do all sorts of other things. You know, the rental agreement's in Spanish, and they do all these things to try to help these folks out. Now, they're trying to make a buck. Don't get me wrong. It is a business, and they're trying to make a buck. But if you're only renting a unit at $300 a month, there's not much of a profit margin there. And a lot of people don't understand that. And so, as well, I believe, at $300 a month, you're only going to get a certain quality. If you want to be up on the north end of town and have a garage and a washer and dryer and whatnot, you know, you may pay $1,500 a month. And a lot of people just simply can't afford that.
You know, owning properties, being a landlord, it's the sexy thing. You know, you're this person with a lot of properties and you're walking around, you know, like the Donald Trumps and stuff. Is it still a good business? I mean, in your opinion, you've seen some bad things, but in your opinion, is it still a good business, specifically speaking, for the younger generation?
I think it's a great business to get into, but with a couple of caveats. The first one is, it is a business, you said it yourself, and you have to treat it as such. And so a lot of folks that feel that it's just as easy as, you know, I buy a place, I put some folks in there and I collect the rent and, oh, look at this great margin I've got. and they don't take into account everything else. They're not following the laws. They don't become a member of the apartment association, so they're not even trying to stay up on what's new and what they are required to do. Their forms are all jacked up. They don't, they're not using the right forms. This is a problem. So for the average mom and pop, my advice would be hire a management company. You can still make a dollar. They will as well, but they're professionals, and they will know how to properly screen a tenant, the proper forms to use. I guarantee you those folks are showing up at the seminars that I teach, whereas a lot of mom and pops don't. They feel that they can just fly by the seat of their pants, and that's dangerous.
We're running out of time this week on the program, believe it or not, but this may be a tough question for you to answer, but as the property's prices go up, are rents going up too? I mean, are you finding some of the landlords you represent increasing the cost of rentals?
Rents have gone up a little bit, but it's very slow in coming around. Fresno's always been one of those markets which, very kind of even keeled. It's not like San Francisco here in California or New York on the East Coast, where rents can just skyrocket seemingly overnight. In California, particularly in the central San Joaquin Valley, things have a tendency to even themselves out. And so the rental market, in fact, one of the reasons why we have so many people on welfare and public assistance is it's very affordable here. And so folks will come from other areas and their dollar just goes further.
Mr. Hrdlicka, how can people contact you? How can, if they are watching this broadcast or listening to it on radio and they have some questions, I mean, are you open to answering questions?
Absolutely. We do it all the time, and we're here locally. Our office is downtown Fresno. We take in the entire central San Joaquin Valley. So, we go down as far as Bakersfield, up as far north as Merced. Our collection efforts go even further in either direction than that. Our local phone number is 559-485-1453. They can also get in touch with me by email if they'd like. And the email address is Steve, S-T-E-V-E, @srhcc.com.
Thank you so much for coming on this program.
Thank you.
That's all for this edition of San Joaquin Spotlight. Thank you to our guest, Mr. Hrdlicka, for coming on the program and talking about landlord-tenant law. Thank you to the audience members watching this broadcast on Comcast and AT&T, the CMAC channel, and to those listening to 90.7 KFSR Fresno. Of course, thank you to the volunteer crew that made this production and every production possible. We couldn't do this without you. That's all for this edition. Tune in next week for a new edition.